Welcome to the Law Rapport. Today we are going to look at bail in criminal proceedings. This is episode 19. And for a quick disclaimer, this is not legal advice. It should not be construed as such. And for legal advice, contact a competent attorney of your choice. Welcome back. There are no bail ordinance in the Turks and Caicos Islands. The section or the ordinance that sets out the requirements for bail is the Magistrate Court Ordinance. And this is applicable whether application for bail is made in the Magistrate Court or the Supreme Court. The court are to take into consideration the requirements set out in the Magistrate Court's Ordinance. Now, bail in the Turks and Caicos Islands is a right, but it is not an absolute right. So, there are certain instances in which a judge or a magistrate hearing an application for bail can refuse to grant that person bail. And the ordinance sets out those situations. So section 89 of the Magistrate Court Ordinance states that where the offense for which a defendant is charged is punishable with imprisonment, the defendant shall be granted bail except as provided by section 90 to 92. So it starts off as bail being a right, but there are exceptions. And if any of those exceptions exist, then the magistrate or judge may refuse bail. Section 90 deals with what it calls absolute exception to the right to bail. It states that the magistrate shall not admit to bail a defendant charged with treason, misprision of treason, treason, felony, or murder. And for those of you who have come across or may have come across this channel previously, when we did our episodes on commonly used terms in criminal proceedings, we give a definition for these terms: murder, felony, misprision of treason, and treason, etc. Now, in my respectful view, this section prohibits a magistrate from giving or from admitting a person charged with any of these offenses to bail. But in my respectful view, it does not prohibit a judge of the Supreme Court from granting bail. Many of you may know from knowledge or may have read in the media, the newspapers, that persons charged with murder were granted bail by the Supreme Court. Now, section 91 creates other exceptions to the right to bail. So a magistrate under section 91, subsection 1, if they are satisfied, A, that there are substantial grounds for believing that a defendant released on bail, whether subject to condition or not, would 1. Fail to surrender to custody, the magistrate could refuse bail. 2. Would commit an offense while on bail. If the magistrate is satisfied, because there are substantial grounds for believing that a person, if admitted to bail, will commit further offenses while on bail, the magistrate, or the judge for that matter, may refuse bail. If there are substantial grounds for believing that the person applying for bail may interfere with witnesses or otherwise obstruct the course of justice, the magistrate or judge may refuse to grant bail. So 1, if there is a fear where there is substantial grounds to believe that a person granted bail may abscond, may absent himself from the jurisdiction of the court, or the jurisdiction of the Turks and Caicos Islands, may not turn up for his hearing, his trial, the magistrate could refuse bail. If there is a fear that is established by those objecting to his bail that there are substantial grounds for believing that that person may commit further offenses while on bail, the magistrate could refuse bail. And if there are substantial grounds for believing that he may interfere with witnesses or otherwise obstruct the course of justice, maybe try to pay off witnesses, try to convince witnesses not to give evidence, try to bribe witnesses, etc. And this could be done by himself or herself or through third parties. The magistrate could refuse bail. If there are grounds for believing and the magistrate is satisfied that those grounds are established, that that person should be kept in custody for his own protection, or he is a child or a young person, then the magistrate could keep that person in custody by refusing bail for that young person or child own welfare. Now, there may be instances where a person may be prone to self-harm, or he may be charged for a matter relating to gang activities, for example, and there may be credible information that he could be terminated, executed, if granted bail, and that may be a consideration for the magistrate to refuse bail. C goes on to say that if it is not practicable to obtain information for the purpose of taking the decision required by this section and section 2, 3, and 4, the magistrate may refuse bail. Now, let us look at section 2, 3, 4, and also section 92, which empowers the magistrate under this section to also refuse bail. Section 2 says that a defendant may refuse bail if, having been released on bail or in connection with the proceedings for the offense, has been arrested. He has been arrested under Section 93, subsection 3, or subsection 5, or Section 95. And Section 93(3) says that if a person who has appeared and has been admitted to bail to appear at an adjournment fails to appear according to the condition of the recognizance, the magistrate may issue a warrant for his arrest, whether there has been any complaint or charge supported by an oath or not. So if a person is granted bail and he breached the conditions of his bail, in a previous bail hearing, then he could be refused bail in a subsequent bail hearing, this breach being used against him, because it could be argued that he will not adhere to the conditions of his bail. Section 93, subsection 4 says it shall be lawful for the magistrate to require any of the following as condition of a recognizance. And when we spoke earlier of bail and bail with conditions, this is what the ordinance was actually referring to. So the ordinance sets out conditions that could be applied by the magistrate in granting bail. For example, a person applying to be admitted to bail may be asked to deposit a sum by way of security, commonly known as cash bail. B, it may be a condition that he reports to a police station at such time and with such frequency as may be required by the magistrate or the judge for that matter. C, that he may be asked to surrender his passport to a police officer. D, one of the conditions may be that he is to be of good behavior and to keep the peace. You are not to get in any trouble or to do anything that could be construed as a breach of the peace while he is on bail. That a condition could be that he will not do or commit some a thing he may be asked to provide one or more sureties in such sums as may be required by the court. And the court could require that he undertake any lawful requirement that it thinks fit. For example, the court may impose a curfew that he should be at home between certain hours, maybe 8 p.m. to 6 a.m. The court may impose what is known as a doorstep condition, that if the police turns up at his residence at a certain hour, he must present himself at the door and said, well, I'm home, here am I, there may be a requirement that he or she does not visit a certain place, a location, that they have no contact with witnesses. Those will, in my respectful view, be deemed as lawful requirements under the ordinance. Section 92 further sets out other considerations to be taken on board by the judge or the magistrate when deciding whether or not to admit a person to bail. Section 92 says that one of the conditions that the judge or the magistrate are to bear in mind is the nature and seriousness of the offense. And the court then are to look at the offense for which the person is charged, how serious the offense is. But in my respectful view, the seriousness and the nature of the offense without more in itself would not be a requirement or would not meet the threshold for the court to say that it will refuse bail. There must be more pressing and urgent and substantive issues on which the court could say that there are substantial grounds to refuse bail. So the seriousness of the offense in itself is not a standalone reason for the court to refuse bail. The court ought to look at the character, the antecedents, the association, and community ties of the defendant. So the court will look at the character. The court will look at, does this person who is applying to be admitted to bail, does he have previous convictions? And not only does he have previous conviction, but does he have similar convictions to the allegation before the court? The court will look at his associations. I think that speaks for itself. The court will look at his community ties. So a person applying for bail with no ties in the Turks and Caicos Islands, maybe a tourist, maybe someone living in the island for a very short period of time, this could, if he has no sufficient community ties, this could operate against him in his application for bail, because this could provide a substantial grounds for believing that he may abscond. However, in my respectful submission, the mere fact that a person who lives in the Turks and Caicos has connections in other countries, maybe Haiti, the Dominican Republic, Jamaica, that in itself would not be a ground to refuse bail, because the court could set conditions that could allay and mitigate those risks, the risk of absconding through ties outside of the Turks and Caicos Islands, surrendering of passport, reporting to the police station, etc., curfew, and the like. C. The court will look at the defendant's record in respect to the fulfillment of bail or his obligations under previous grants of bail in criminal proceedings. So the court, if the person was previously on bail or a person was granted bail previously, the court will look at, did he abide by the conditions? Did he breach his bail, his previous bail? And if he was a person previously granted bail and breached his bail, this could weigh against him. Those are considerations that will be at the forefront of the court's mind. D. The court should consider the strength of the evidence of the person committing the offense or having defaulted. So the court will have to look at the evidence that the prosecutor or the prosecution is relying on in the offense for which the person is charged. However, in my respectful submission, the strength of the evidence alone without more would not be sufficient for court to deny bail. Neither is the likelihood of a long prison sentence. There must be other factors that the court must take in the wrong before the court could say that they are satisfied that there is substantial grounds to believe that a person, if admitted to bail, would abscond or would not surrender, would interfere with witnesses or would commit other offenses while on bail. Now, in the Turks and Caicos Islands, there is no right of appeal in the from a refusal of bail in the Supreme Court. And while bail, a refusal of bail, could be subsequently reviewed by the court refusing bail, or perhaps by another court, there is no right to appeal from a refusal of bail in the Supreme Court to the Court of Appeal. However, if there's a refusal of bail, the Magistrate Courts, the Criminal Procedure Rules provides that this decision can be reviewed by a judge of the Supreme Court. So a person being refused bail in the Magistrate Court, the Supreme Court can review to see if the magistrate was right in denying or refusing to admit that person to bail. But if the person is refused bail in the Supreme Court, there's no right of appeal to the Court of Appeal. This is where I will leave it for today. Thank you for watching, and I will see you in another episode.